Does call the case of the People's State of Michigan versus LaPortia Murray.
Interfield is appearing on behalf of the people.
Good afternoon, Your Honor. Sam Bernstein on behalf of Ms. Murray. Your Honor, I apologize for my lateness. Should have scheduled some things a little bit better. And
well, no, I understand that you were down in Judge Slay's court, so we were willing to wait and make sure you got that taken care of in that year. So we're good. All right, very good. The court has received both the people's brief as well as the brief from the defendant and has reviewed both of those. Was there any additional argument from either side?
I guess the one thing I would like to just make a brief argument.
Yes, that's fine.
My colleague, Mr. Evans, did most of the argument on Tuesday, all of it, rather. I will preface this with, I apologize for bringing something up that I think we thought we had put to bed on Tuesday, which is this whole notion of, as in my pleading regarding the first degree child abuse with the felony murder.
Okay.
Which, you know, as I went down the road of legal research, in speaking about candidly with some individuals from PACPAN regarding their child abuse cases, I discussed the matter, and they pointed me in the direction of this Maison case, which I cited in my pleadings. And I'm not trying to, I know judges don't like it when you keep arguing your point, even though we're lawyers, right? And we can't help ourselves sometimes. And so I felt that, based on that law, I had to make that argument. That's included in the brief. And I think,
well, let me ask you about that.
Yeah.
What particular point are you trying to make with the Maison case?
so the important, and stop me if I'm incorrect, but my recollection of Tuesday was the court's concern over child abuse first degree, and then kind of by that, which leads to the felony murder. The court's concern over child abuse first degree was a discussion of what arguments do the people have to show that the defendant in this case did the harm, right? And that was a very, very pointed question by Your Honor to Mr. Evans about that. In reading the Maison case, what the Court of Appeals says is that it's an interpreting child abuse first degree versus second degree. Second degree specifies you can either do it by an act or do it by omission. And child abuse first degree does not discuss the idea of an act versus an omission. And the Court of Appeals concluded that their interpretation of the child abuse first degree does not require an act, and it can be done through an omission if that omission is knowing and willful. And thus causes the harm, a serious physical harm, which I think, without question, we have a serious injury to Lariah Henning. That's of all the things we can argue, that's not worth arguing. So my argument is that through my reading of the Maison case in analyzing it within the context of the facts before the court, I want to make the argument that through the defendant's conscious decisions to not get Lariah care, and this is in the pleadings, and I think these decisions by the defendant were based on her own statements, fully aware of that Lariah had something going on, right? She made the statements, she thought she would maybe fall, and this, that, and the other. Obviously, it's the people's contention. And this hasn't been necessarily borne out by facts that I think the defendant had something to do with that, but that's not important. What's important is that the defendant, by her own admissions, acknowledged that Lariah had suffered harm and that she knew she should take her to the doctor, and that she didn't want to take her to the doctor because she didn't want the doctor to see the physical abuse that she did to Lariah, not necessarily the head trauma, but these other markings that even Dr. Toshkin testified to that were on the body, on the back and things of that nature. And so through the defendant's knowing full well that she needs to take her daughter to the doctor, but she doesn't want to get in trouble, that is a very conscious and intentional decision by the defendant to not take the child for medical care, which ultimately likely would have saved her life, but wasn't done. And this is not over the matter of hours or minutes, but this is days that this went on. But
can I just ask, because as I read the the cases where they haven't taken for medical care. That medical care is specifically directed to the injuries that cause the harm. Right? And I guess the court is having a difficult time in this case because had she known, for example, irrespective of the other injuries, of trauma to her head and had failed to do it, I see the argument. Here, I don't have anything that says that.
Well, and I understand that point, and my argument would be that there are facts before the court that would suggest that she knew that this injury was a significant injury, because when pressed by Detective Sinks in her statement to Detective Sinks, she acknowledged that she may have fallen down the stairs in this townhouse in the apartment that they lived in, and that after the fact she was not eating and drinking and had trouble with mobility. Now, I'm not saying that the defendant's a doctor or I'm inferring that sort of expertise, but I think as a parent with a 2-year-old that falls down the stairs and then is having all these issues, it's a reasonable to assume that there is some sort of head injury, because what we don't have is any evidence of cuts, bruises, scrapes, vomiting blood, things like that would suggest some other type of injury. But we have someone who's acknowledged that their kid fell, right? Had call it an accident, call it whatever. But we don't have, if it was a situation where Lariah cut her leg, right? And turns out she had also hit her head, but the Maison case deals with, starvation, which led to pneumonia, and then the kid ultimately succumbs to the infection. So it's I think the Emmy testified that in that case that the malnutrition would contribute to the infection because the body's unable to fight off. I don't think that's terribly different than what we have here. We have knowledge by the defendant that her daughter suffered a fall, and that the subsequent effects of that were changes in her motor skills, in her appetite, and her.
But do we really know that? I mean, was that really the testimony? Because in one instance, there's a 4-day period, and then there's like a week period in terms of exhibiting certain symptoms. But I don't know that it was pointed out that that's after the fall.
My recollection of, and again, this is probably part of the issue when we bifurcate an exam like this, which stinks. And so I'm relying on my memory, and my recollection from Detective Sink's testimony when I asked him the questions about the statement made by the defendant was that the defendant admitted to Detective Sinks that Lariah had fallen down the stairs or had some sort of accident, and that after that occurred, exhibited a loss of appetite and wasn't drinking, as well as issues with mobility. I forget the exact phrasing, and not only that, she admitted to Detective Sinks that based on what happened, she knew she should take Lariah to the doctor, but she didn't want to get herself in trouble because of the injuries and potentially getting CPS involved.
But that was because of but that wasn't because of the fall.
It was because of the fall.
That she wouldn't take her to the
hospital? Yes.
I don't recall that. And maybe you're right in terms of this. I need to go back and look at the record. My recollection of why she didn't take her to the doctor was because of...
All right, pause right here. This is important. When a judge says they've reviewed both briefs, that means today isn't about emotions, it's about law versus law. No grandstanding, no theatrics. This is where legal precision decides whether charges live or die.
Either spankings or parental disciplines or the plastic belt.
No. The Well, she didn't want to take her to the doctor to expose those injuries to the doctor, but she, in her statement to Detective Sinks, admitted that she knew she should take her daughter to the doctor because of the fall, because of the effects that Lariah was
Well, hold on
suffering
a second.
after the fall.
Okay, and there may be the distinction. It wasn't because of the fall itself, but what is now claimed to be what was being exhibited by the child after the fall.
Right.
Okay.
Yeah, there was no statement by the defendant that as soon as the fall happened, she realized she should take her. And I don't think there's any, even from a physiological standpoint from Dr. Tashin's testimony, that there necessarily would have been an immediate reaction by Lariah to this traumatic brain injury. I mean, she may have been momentarily incapacitated. Who knows, right? The testimony by Dr. Tashin was that the traumatic brain injury caused a swelling of the brain that over this 3 to 5 days increased, and ultimately caused her to die. And that he testified you would expect symptoms to manifest over that time period, consistent with, frankly, with the observations that the defendant made about her own daughter. These things like loss of appetite, trouble with mobility, whether or not she's speaking, and things of that nature. And so, yeah, there was not a statement that immediately after the fall, I knew I should take her, but there was a statement to Detective Sinks as the defendant began to admit of symptoms that Lariah was showing in these days after the fall, that she knew she should take her to the doctor, but didn't want to get herself in trouble. And so I think that based on those statements by the defendant and actions, that we have a situation where I'm making the argument this is in fact a child abuse first degree, and that the failure to get the requisite care and well-being for her daughter led to her death.
But you would admit that factually there's distinctions between the two cases as primarily relied upon by the people in this case.
Of course, yeah, of course.
Yeah, I
of
mean,
course.
but yeah, I mean,
I do.
they're
not the same.
Right, because in one case I have asphyxiation and suffocation where there are these sort of overt acts, right? Even in my son's case, I have people who are not feeding a child.
Right, there's more visible cues and things like that. I 100% agree with the court.
Okay.
Yeah, I'm not, you know me, Judge. I don't try and oversell things.
No, I know. And I'm just, because as I'm looking at it, yeah, okay.
And I guess my final point is, I think it's also important to the actions of the defendant, as well as the clear lies that she makes to Detective Sinks, as well as the deputies on scene and subsequent at the hospital. I'm making the argument that does show her consciousness of guilt, even more so that she knew she needed to get help for her daughter. And what's really, really troubling, and it literally keeps me up at night. We have a kid that probably died around 7 a.m. on June the 28th. And the police aren't called until 12:53 p.m. And when the police arrive, we have the defendant theoretically performing life-saving CPR on a child that has been dead for 6 hours and is cold to the touch. And my argument for the court and the people's position is that it's a ploy, it's a ruse. It's trying to distract from the fact that the defendant knew that she was in big trouble because of what had happened to her daughter, and that her daughter was dead and had been dead and was laying in the living room with soiled underwear for hours in a house where nobody bothered to try and get care. And I think that along with these lies that, she died around 11 a.m., she died in my arms, things like that, the court can consider those, obviously, or at least it's the people's position. The court will consider what it's going to consider, but it's the people's position that those sorts of, deliberate, clear lies that are not backed by evidence in any way, shape, or form, along with the defendant's own statements that she knew she should take her child to the doctor, show this consciousness of guilt that she absolutely knowingly and willfully kept her daughter from getting the care that would have saved her life. And that's my argument. Thank you.
All right. Thank you. Mr. Brenton.
This is the core legal battlefield of this case: act versus omission. Did the defendant do something, or is the prosecution saying she's guilty because of what she failed to do? That distinction might sound technical, but it's the difference between first-degree charges and everything collapsing.
I don't want to oversell anything either. I don't know where things stand, but I'll pare down kind of what I was planning on talking about, Your Honor. Following the hearing last time, I did some more digging really into the case law surrounding child abuse in the second degree. And there's a line of cases from the last 5 years or so that define very clearly what an omission is. They look at the word omission in the statute itself. They parse the legislative intent from omission. In the case of People v. Bryant and others, I think make crystal clear that an omission in the child abuse statute does not include medical neglect. And so, the argument that it was an omission that led to serious harm here, it fails, because even Maison talks about what omission is, but it's subsequent cases that further define what an omission is and define that it's not including of a category of medical neglect. So I think we can look at all the cases in that light, Your Honor. It seemed like the court picked up on kind of the factual differences between Portelis and Maison in the case at bar. I would also note that a lot of the cases decided about what an omission is come after Portelis and Maison. So we have more clear definitions of what an omission can and cannot be. I did look at the case of People v. Maynard. It's a case in the notes of the jury instruction of first-degree child abuse. It's a leaving the kids in the car case. It elaborates like a two-pronged test for what it means to commit first-degree child abuse. Talking about the statute, it says, thus, this language requires more from the defendant than an intent to commit an act. The prosecution must prove that by leaving her children in the car, the defendant intended to cause serious physical or mental harm to the children, or that she knew that serious mental or physical harm would be caused by leaving them in the car. So there's more of a two-pronged test. It's not just an omission, it's an omission with intent to commit or knew that there would be harm. Frankly, I don't see that there are proofs that Ms. Murray, through medical neglect, either intended harm or knew that there could be harm. There really just weren't any proofs about the child's state between injury and death. It could only be speculation. There were no proofs relevant to that, so we just don't know. The pathologist did testify that he wasn't an expert on what could happen with or without medical intervention for Lariah. He said he could only really speculate as his position for a pathologist. I would just ask the court to look at those cases and take those into account when coming to a decision here. Thank you, Your Honor.
When the court has looked at all of the cases that were referenced by the parties in there, so on the court's recollection of the testimony, one of the things that's in the court's review of the court's notes, I haven't gone back through the video as I didn't foresee it as being necessary. However, I look at there are clear factual distinctions, and one of the problematic things here is the notion that certain actions or inactions alleged by the defendant would require the court, at some point, you're building on these inferences of certain things and trying to piece them together. And I don't know that that's the court's job necessarily at this particular point in time, to try to figure that out. Some of that may have to go to a fact finder if the court finds that it would be proper to the defendant stand trial. It is I could say you're first degree child abuse because you're a horrible mother. And I don't think that that's the court's job either. Or at least a horrible mother as it regards this child and what she should have done or could have done. But one of the problematic things about the cases that are cited is
Let that sink in. The prosecution isn't just arguing neglect, they're arguing intentional avoidance, not going to the doctor, not because she didn't know, but because she knew too much. That's the emotional weight behind this argument, and juries tend to feel that deeply.
is some act. There is something. And that was the point that the court was making at the last hearing that we had, giving the people every opportunity to tell me what it is alleged that Miss Murray did. And it just seems like the argument would be one of a negative to get to that point that she did something. Certainly what she should have done in terms of medical care and the like. But realizing that the cause of death being the blunt force trauma to the head, for the most part, or any part, quite frankly, at least according to the medical examiner, there just isn't that connection that the court would see in terms of what Miss Murray did or didn't do. That's a huge distinction for the court in terms of these other cases, because in these other cases, there's something that these people are doing to the child. So in that respect, and after due deliberation and reading through everything, and as the court examines the facts of this case, the court is going to decline to bind the defendant over on the charge of felony murder and or child abuse in the first degree. I also do not believe in this case that the elements, let me make sure I say this clearly. I do not believe that this is indeed a second degree murder case, and don't believe that the defendant should stand trial on the charge of second degree murder, primarily for those same reasons. But the issue of malice and intent, certainly, or at least malice, implied or expressed, it certainly come to the court's mind as I review the facts as I have them in this case. I think it's appropriate that the defendant is bound over to stand trial and will bind the defendant over on the charge of child abuse in the second degree. I will, as requested by the people, bind the defendant over also for, and I understand their reasons for child abuse in the third degree, and also the charge of involuntary manslaughter. So I will bind the defendant over to stand trial on those three, and I probably should put them in a different order for the purposes of clearance.
So I will file an amended information with those three counts in the appropriate highest charge.
Correct. Thank you.
And I'll make sure that that's sent to Mr. Bernstein.
All right. All right. Mr. Bernstein, do you waive presentation of the information at this time?
Yes, Your Honor, I can waive.
All right, and stand mute to those, your client stands mute to those charges and waives its reading, obviously.
Yes, Your Honor.
All right. Defendant having waived presentation, formal reading, court will enter a not guilty plea.
This is where things get dangerous for the prosecution. They're trying to link two very different scenarios: starvation leading to infection versus a traumatic brain injury. Courts don't like stretching precedent, and you can hear the judge wrestling with whether this comparison really holds up.
On the defendant's behalf, pretrial in this matter will be set
July 10th at 1:30 before Judge Company.
July 10th, 2024, 1:30 before Judge Company.
Perhaps a Judge Conlon case, I want to say.
I'm sorry, that is I meant to say Tom, it is Tom. Correct date, but it should be Tom.
What'd you do? You've been doing this all day. So it's,
I wasn't calling your eyes, making sure I go to the right room.
it's July 10, 2024, 1:30 before Judge Conlon.
This moment right here changes the emotional temperature of the room. Performing CPR on a child who's been dead for hours isn't just tragic, it raises questions. Was it panic or was it a performance? That's what the prosecution wants the court to believe. And here's the shocker: despite everything you just heard, the judge says not enough, no felony murder, no first-degree child abuse. This is a textbook example of how moral outrage does not equal legal proof and why judges separate sympathy from statute.